Good morning, everyone. We're just waiting for a few extra people to join. We'll start very shortly. Okay, we'll press on. Welcome, everyone, to our latest webinar. To those of you joining us from around the world, just to say that this will be recorded so that we can post it later on if we decide to. I'm Chris Soph with Gleeds, overseeing our International Dispute Advisory Group. I'm a past president of the Chartered Institute of Building, a fellow of the RICS, and I'm on the national panel of the American Arbitration Association. And I'm speaking to you today from Atlanta in the United States. I'm delighted to introduce this third and final 2024 webinar, where we'll be discussing issues affecting megaprojects. On the first webinar, we discussed setup strategy for megaprojects and the considerations that are involved in planning for high-profile, ambitious infrastructure projects that they are. On the second webinar, we discussed project execution and the issues that arise when planning a mega project meets the reality of delivery. We discussed how the beginning of a project can feel like the honeymoon period, when in fact it is because it's actually a very high risk time and when most of the unexpected issues arise. We also discussed the challenges of managing documentation during project and the difficulties around completing the works. In this webinar, we'll discuss the management of disputes on mega projects. If not properly managed, disputes can severely impact progress and can affect outcomes through delays and cost. There are various reasons why projects might end up, but much of the time the disputes can be traced back to the way in which the project was set up and then executed. Disputes tend to be the result when implementation plan of a project is incompatible with the reality of delivery and execution, and when parties are working only to protect their own interests rather than those of the project as a whole. As we've discussed before, there are a large number of mega and giga projects currently under construction in the world today, particularly in the Middle East. At the same time, the global value of construction disputes continues to rise. In the Middle East region, where the average value of a construction dispute runs to tens of millions of dollars. For mega projects where the stakes are higher and the projects are high profile, an expensive dispute is the last thing that anyone wants. What is important is how the parties effectively manage these disputes. In our view, the impact of disputes can be limited or even avoided altogether with the right mindset and the right behaviours. As we've advocated before, a mindset that puts the project interests ahead of the party's own interests is healthier approach to the project and is likely to reduce the likelihood of disputes arising. Even if disputes do arise, parties that adopt a pragmatic mindset are more likely, in our experience, to arrive at an amicable settlement and a solution that enables the work to continue and to be completed with as little disruption as possible. We're delighted to welcome our international panel, who combine legal, technical, and practical experience. The panel will share their experience of managing mega project disputes and provide insight for the benefit of our attendees today. We'll discuss the strategies that work to successfully resolve disputes and to ensure success in the delivery of the project. We'll allow some time to answer your live questions today after the panel discussion, so please feel free to ask us any questions or tell us about the issues you're facing on your projects. Please submit your questions using the Q&A function, and we'll attempt to get to as many of them as possible during question time. Our panel today again consists of legal and technical experts from Freeths and Gleeds who have experience in dealing with all aspects of mega projects, from setup to delivery and conflict avoidance. Plus, we have the pleasure of welcoming Megan Bachman, a partner at Crowell and Mooring, as our special guest speaker. Megan leads clients in resolving complex and high-stakes disputes, crafting strategies for resolving disputes, and is experienced in international construction and arbitration law. Gleeds and Freeths have joined forces to create Construction Disputes A to Z. This is an initiative where we offer one-stop technical, contractual, and legal service to clients, and we've made available our marketing material on this initiative as a handout for this webinar. If this webinar raises any issues on your project where you think we could help, or you think you may have need of our services, please don't hesitate to email us. Our email addresses are on the slide you can see on the screen. Alternatively, please connect with us on LinkedIn, and we'll be happy to have a no obligation discussion about the issues you'll be facing. I also want to mention that our previous webinars are available to view on the Gleeds YouTube channel. This one will be too. Once we've finished, just go to YouTube and search for Gleeds and select videos. So with that, we'll move on with the main business, and I'll let the speakers introduce themselves. Alex.
Many thanks, Chris. Welcome, everybody. My name's Alex Johnson, and I'm with Freeths. I'm a partner specialising in construction and engineering disputes, based here in the cold UK, but my practice is international. So I work for clients based all over the world on some of the most complex construction disputes. I advise clients at all stages of a construction project, but mainly towards conflict avoidance and dispute resolution. But this can take the form of strategic advice on issues that might arise during a project, on alternative dispute resolution, litigation, or international arbitration. And my experience with mega project disputes is particularly in major infrastructure, oil and gas, and energy sectors for projects around the world.
Thank you, Alex. John?
Thanks, Chris. Hi, everyone. I'm John Refat. I'm a director of Gleeds Egypt. I'm a chartered quant surveyor. I'm a member of Chartered Institute of Arbitrators. I'm a board member on RICS Egypt Market Advisory Panel. I'm having over 20 years of international experience in the field of project cost management and dispute resolution on high-profile projects within large developers, cost consultant, and first-tier contractors at senior level in the MENA region. I have been personally involved within several mega projects, such as the development of Dubai Festival City in United Arab Emirates, Cairo Festival City, Marasi and Saud projects in Egypt, Etim project in Pakistan, King Salman Park and Shusha Island projects in Kingdom of Saudi Arabia, among others.
Thank you, John. And Megan, our special guest today.
Oh, thank you, Chris. And I should say good morning to you and good evening from where I'm joining you. I'm actually in Dubai, but I'm a partner in our Washington, D.C. office of the law firm of Crowell and Mooring. And for the last 2 decades, I've specialized in infrastructure disputes, particularly those arising out of international infrastructure projects. But I've worked on a fair number of U.S.-based projects as well. And like Alex, with whom I had the privilege of working with at our prior firm, I like to also plug in at all stages of a project in order to apply lessons learned from my disputes work to help clients reduce and narrow claims and hopefully avoid the ultimate disputes that we'll be talking about today.
Thank you, Megan, and welcome. Thank you for joining us today. So just a little on our questions policy again. Please remember to submit your questions to the Q&A box, and we'll leave time at the end to answer them if we're able. Past experience tells us that we won't get to them, so if you all of them. So if you have any questions or issues after the webinar, please mail us, email us, and we'll be showing our contact details again at the end. Alternatively, do connect with us on LinkedIn and ask us your questions directly. So with that, on with the first question, a very broad one. What causes disputes on mega projects specifically? And we'll go to Alex first.
Thanks, Chris. Thank you for such an easy first question, to which there's, I think, a complicated and a simple answer. I'll deal with the complicated answer. I think there are many different factors that can cause parties to be in a mega project dispute. Those are specific to the type of project, to the parties themselves, to the contract, to the work involved, to the risks that arise, etc. And it's in the specific details of individual cases, such as welding is not being performed correctly, or material is corroding that was not supposed to, or the design is not workable in practice. Any dispute is a mixture of these kinds of factors. But the simple answer is, I think, to say that ultimately people cause disputes. And that's because at one point, one of the parties will choose to be in a dispute, much as they may claim to have been forced into it or, had no other choice. And so I think there's always a moment that causes one party to formally contest a dispute, and that's usually by exercising rights to refer to arbitration or to litigate in a national court. So a dispute isn't something that just occurs. I think it's often a flaw that gets baked into the formation of a contract, and it develops during the early stages of the project. So typically in EPC contracts, problems with design will only manifest themselves during construction, for example. And equally, errors and omissions in contract documents is also a common feature of disputes, but it could, and I think arguably should, have been caught before the contracts were signed. Often that doesn't happen because the contracts can sometimes be an unorganized mix of legal and technical information. So I think an issue that has potential to cause a dispute is usually the result of the plan not meeting the reality in terms of how the project's been set up and then executed. Whether that turns into a dispute, I think, is in the hands of the parties. So that's why I say, in my view, I think it comes down to the people. So with the right behaviours, I think if disputes arise in the first place, they can be resolved effectively and in a way that allows the project to continue, and they should not be considered as inevitable. I think in the case of mega projects, the scale of the project, the pressure, the publicity and the demands that are involved are all very significant factors. And as we've discussed in our previous webinars, mega projects are vast in terms of the space that they occupy. They're subject to ambitious schedules, they're subject to intense scrutiny and publicity. And this means that the sums in mega project disputes will be very high. And that tends to make the mega project dispute a particularly intense and stressful environment for those involved. So I think to limit the causes of mega project disputes, parties do and need to work hard to put the project first and create the conditions that are more likely to lead to dispute avoidance than to formal dispute resolution.
Thank you, Alex. On to John. What's your opinion, John? What causes disputes specifically on mega projects?
Various factors, Chris, actually, often due to complexity and scale of these projects. From my experience, some of these causes are actually due to that mega projects are considered first of a kind project and generally involve new technology and unprecedented scales, leading to unforeseen challenges. There is also the insufficient information or lack of detailed information can hinder effective project controls and scheduling. Scope and schedule creeps as changes in project scope and delays can disrupt timelines and budget. Culture difference is also an important factor as disparities within or between organizations can lead to misunderstandings and conflicts. Misalignment on the commercial objectives as differing goals among stakeholders can create friction. Poor contract documentation and administration as overlooking contract details can result in disputes over responsibilities and deliverables. Inadequate risk management as poor allocation and management of risk can lead to a significant issue. So I would say addressing these factors early through careful planning, clear communication, and robust contract management can help to mitigate disputes in later stages.
Thank you, John. Good advice there. And on to Megan. Megan, what in your experience causes disputes on mega projects?
Yeah, I just want to echo what Alex and John have just said, that the complexity of mega projects, especially when you talk about the complexities of the interfaces, whether they're interfaces between works packages or schedule interfaces, existing and new builds, and also in terms of the complexity of the specialty and often first of a kind technology involved, those really are frequent sources of disputes on mega projects. I would also especially underscore what Alex said, that at the end of the day, people, not processes, deliver mega projects. So the role of specific people or personalities on a project is sometimes maybe an under talked about driver of disputes on mega projects. But on the flip side, I think as Alex was also alluding to, they can be a positive driver for dispute resolution or disputes avoidance, especially where projects are led by people who adopt a project first rather than a me first approach. A few further points that I want to just highlight as causes of disputes on mega projects especially are poor or overly optimistic cost estimates for projects. This is especially an area where both sort of the optimism bias that is known to plague mega projects comes into play, as well as really the political nature of these projects and maybe the desire to sell a project to the public or the legislature or whomever is the one making the decision as to whether this project gets built. And I think, in other words, really the continuing propensity of human beings to convince ourselves and others that we can succeed where others have failed, and that, notwithstanding that it's a mega project, it can be done faster and cheaper than anything else in the world. Another would be poor stakeholder engagement during the planning and design phases, so that end user or other stakeholder requirements are not written, signed off, and properly captured in the design and in the project, or if they can't or won't actually be captured, that is known and acknowledged formally by everybody. Fast tracking is another feature of mega projects that, or I would say a common feature of many mega projects that can lead to disputes, especially if fast tracking it means commencing a project with unfinished design, where the contracts don't have robust mechanisms for adjusting price or schedule while maintaining progress. As with most projects, but probably more so with mega projects, bad design, or maybe to be more balanced, designs that by virtue of being first of a kind or at a mega scale are challenging to engineer and design, and such that problems with the design don't really manifest until the project gets underway, or especially those interfacing parts of the project are incorporated. And I would say that probably one of the last features that I see, causing mega project disputes would be siloing. And I think that's relevant not just in terms of managing the interface complexity and how failures to properly manage interfaces can lead to extremely challenging disputes, but also in terms of how siloing in any aspects of the projects, especially information sharing, can exacerbate challenges and lead to misalignment on projects.
Thank you, Megan, and super information there. Optimism bias coming up again. Lots of causes. I suggest, being adaptable, being proactive, thinking of the shared project goals, behaviors coming up again, get the communications and documentation right. Of course, we've got a lot of causes that our experts have mentioned there, and often as dispute experts, it's quite straightforward to figure out cost and quantum and causation of one cause, but a lot of the time you get 4 or 5 of those different things all in together, and that's when it becomes very difficult to sort out the dispute and how much is involved and how to solve it. So thank you all for that. The second question, what behaviors would you recommend for avoiding mega project disputes? So there's one coming down the tracks. What do we do to try and avoid it in the first place? Alex?
Yeah, thanks, Chris. I think it's important that the parties on the mega project should have the mindset of always putting the project first. And that means treating the project as an investment in which they all have a stake. And so not having an adversarial mindset that's focused on protecting one's own interests. I think if parties recognize that they want the same thing, that they both want the project completed for different reasons, owners so they can take over the asset and start generating revenue, and contractors so they can finish the job, get paid and move on, then there's a common cause there. So I think if parties adopt this type of mindset, then they're better predisposed towards collaboration as opposed to combat. And this pivots them towards problem solving rather than conflict. And so ideally, this is a mindset that should begin on day one. It would affect how the contract terms are drawn up and how they're negotiated, which may lead to a more amicable risk distribution, and ultimately how setbacks and disputes are then dealt with. So rather than referring a dispute straight to arbitration, a more collaborative mindset might prompt parties to consider real-time dispute avoidance methods such as dispute boards, adjudication procedures, or expert determination provisions. And those are all mechanisms aimed at resolving disputes when they happen and allowing the project to continue despite the dispute. Dispute boards in particular have got a good track record. They are effective in relation to mega projects if they're used. They have been used, for example, in Olympic Games infrastructure projects, which are by definition usually mega projects, and they usually come with a non-negotiable completion date. The dispute board is a contractual procedure that provides a panel of experts that will convene and review the progress of the project, make interim and non-binding recommendations to resolve issues as they arise without them becoming disputes. And whether that's effective usually depends on who's on the panel and whether the parties trust them. For a mega project, I think a dispute board makes commercial sense as the cost of it is justifiable, and that's maintaining it throughout the course of the project. And so it's obvious that the 2017 FIDIC suite includes the Dispute Avoidance Adjudication Board as standard wording. But the collaborative mindset, I don't think is just contractual. I think it drives the way that parties work together. So it could be that the parties would decide to depart from the dispute resolution mechanism in the contract if the result is just a formal dispute. So my experience, particularly in the oil and gas sector, where the numbers involved are very high, is that parties seem more prepared to avoid or resolve disputes without looking at the contract. So by agreeing to amend the contract, and that can involve agreeing extensions of time at a contractual level and incentivization payments to keep the project on course. So there are options beyond the contract for avoiding and resolving disputes, but I think mindset is key as to whether those are considered or not.
Thank you, Alex. John, what behaviours would you recommend for avoiding mega project disputes?
I actually totally agree with Alex about the requirements for a proactive and collaborative behaviors. Some of the key recommendation I would actually communicate to our audience is clear communication, ensures that all stakeholders have a clear understanding of the project goals, set the right expectations, foster a change management process, have a regular update and open challenges for feedback. Actions can prevent misunderstandings and help collaborative cultures. So again, foster a culture of cooperation, mutual respect among all parties. This includes encouraging teamwork and addressing issues promptly and constructively. Have a detailed planning, invest time in through planning and risk assessment at the project's outset. Clearly define roles, responsibilities, and deliverables to avoid scope creep and misaligned expectation. Effective contract management, again, draft clear and comprehensive contracts that outline all terms, conditions, and procedures for handling changes and disputes. Regularly review and update these documents as needed. A proactive risk management to identify all potential risks early and develop mitigation strategies. And again, regularly review and adjust these strategies as the project progresses. And the most important thing is a continuous learning and improvement. Encourage a mindset of continuous improvement, learning from past project, and apply this lesson learned to current and future project. And the most important part is the stakeholders' engagement. Actively involve all stakeholders in decision-making processes to ensure that their concerns are addressed and their input is valued. This reduces the likelihood of conflicts. So again, trying to implement some of this recommendation can significantly reduce the risk of dispute and contribute to successful delivery of mega projects.
Thank you, John. And over to Megan. What behaviours would you recommend for avoiding mega project disputes, Megan?
Yeah, well, I would just wholeheartedly agree about the importance of a collaborative culture for delivering projects generally and mega projects especially, and how that kind of culture can correspondingly reduce disputes. I would say that part of that collaboration for mega projects especially includes recognizing that there may be sort of different levels of client and end user maturity for a mega project, and that, you know, management structures, processes, and approaches have to be aligned to that status quo. For example, not all mega projects are going to be delivered for an experienced owner like the UK government. Not all projects are going to be like the Olympics in London. And indeed, many of these mega projects are being done in more developing markets or countries where the owner and the stakeholders might not have ever procured anything of that scale or complexity before. And so there may be some adjustments in project delivery that need to be made to make sure that everyone is continuously on the same page, is continuously collaborating. And I think in that vein, I can't really underscore enough something that both John and Alex have also spoken to, which is the role of clarity in reducing disputes, not just in the contract documents, of course, but in communicating about the project at every stage. Obviously, there's a fundamental requirement that a project meet the client's requirements. And so it's a prerequisite that the client's requirements are actually known and understood by all project participants. And so, a proper project brief that's carefully prepared and then checked against and updated throughout the project and widely circulated can be a really essential part of achieving that required clarity, since that's where the core objectives and requirements for the project are recorded for all the parties.
Thank you, Megan. So common themes arising there from the experts: a well thought out project brief, get into the right mindsets, collaborative culture, proactive risk management. And I think the other one I'd add is not sweeping things under the rug, but flush them out and get them solved as the project progresses. And there are many times when that doesn't happen, and the attitude is to deal with it all at the end. That kind of doesn't work. So third question, how should a party prepare for mega project disputes? So it's an actual dispute on the table. So what do we do to get set up for it? Alex?
Yeah, I think the key is to ensure that evidence is collected, preserved and organized, and that should happen throughout the lifetime of the project. And the reason is that ultimately evidence is what wins cases. So the party that has more and better quality records substantially increases its chances in either successfully prosecuting a claim or defending one. And for contractors in particular, I think it's very important that contractual procedures that call for notices to be given within certain time limits are complied with, because that will preserve entitlements to additional time or payment, whatever it is that's being claimed. And failure to comply with the notice requirement can bar an otherwise substantial entitlement. So it's a key thing to get correct. I think parties should also be careful about how they communicate and what they say. There's obviously an official correspondence which is maintained in the project record, and I've advised clients on drafting important letters, for example, those that will assert an entitlement or reserve rights. And those communications, therefore, are usually well controlled. But of course, there's the other side of it. There's also all of the less official communications that parties send to each other. And under English law, the category of disclosable documents in legal proceedings covers not only the official project record and company emails, but also personal emails, WhatsApp messages, social media posts, metadata. Basically anything that's recorded information is potentially disclosable. So if unguarded comments are made in unofficial communications, those have potential to be embarrassing at best, or at worst, they could be very damaging or undermine a case if those are disclosed in the proceedings. And I think the final point is probably to ensure that rights are reserved in correspondence. So if you become aware of a matter that has got potential to become a dispute, then it's always sensible to include express reservation of rights wording to ensure that contractual or legal rights are not waived or stopped. And this reservation is essentially designed to protect the party's position, to keep its options open and avoid the waiver of any rights.
Thank you, Alex. John, how should a party prepare for a mega project dispute?
More records, actually. Maintain detailed records for all project-related communication, decision changes. This includes email, minutes of meeting, contracts, and any other relevant documents. These records, as Alex was saying, can provide critical evidence if a dispute arises. Address potential disputes early through negotiation or mediation to prevent escalation. I also recommend that you implement a multi-step dispute resolution process, starting with negotiation, followed by mediation, and if necessary, arbitration. An important thing is to consult with legal and technical industry experts to understand the potential legal implications and technical aspects of the project. This can help in drafting robust contracts and preparing for possible disputes. Actively involve all stakeholders in the decision-making process to ensure their concerns are addressed and their input is valued. This also helps preventing conflicts from escalating. And the most important part is about your team on the project. Train your team on the importance of documentation, communication, and adherence to contract terms. Awareness of this aspect can help in early identification and resolution of potential issues. I always advocate for conflict avoidance rather than dispute resolution, Chris. So this is one of the important points actually to consider.
Thank you, John. So lots of proactive steps there. Megan, how should a party prepare for mega project disputes?
Yeah, thanks, Chris. I agree wholeheartedly with what John said. Records. The quality and organization of the project record, including especially when you consider the massive amounts of data that are generated along the many years that a mega project usually takes to deliver. Those are going to be critical to every participant on a mega project being adequately prepared for a dispute should it become unavoidable. And as John said, one hopes that few disputes are unavoidable. And not only is it important to have also good document controls, contract requirements, and procedures for organizing and keeping this project record, but I think, as John alluded to, your participants really do need to have superior management and execution of those procedures wherever possible, given the challenges of a mega project. And in respect of the documentation that is generated and maintained, one thing that I think bears particular emphasis in establishing causation for both a breach and the consequences of that breach is that on a mega project that can be particularly challenging, not just because of the complex nature of the works, but again, especially because of the extensive interfaces, spatial time systems that exist on mega projects and the number of potentially intervening causes that different parties might be pointing to when things get behind schedule, cost more, or the requirements aren't met. And so I think that if possible, special attention to documentation with an eye to creating documentation with an eye toward understanding and really documenting the facts of what is occurring and wherever possible, the causes and consequences contemporaneously can go a long way in any ultimate dispute. And I also just want to briefly pick up on something that Alex mentioned earlier about dispute boards and proactive claims management. These are important not just for helping parties solve disputes along the way so that the project can progress, but I think they're also helpful in helping parties narrow the issues that will ultimately be litigated in any ultimate dispute. Because mega and giga projects are by their nature huge, the scope of the disputes can also be very extensive, and it won't always be possible, but and especially if you have a counterparty that's unwilling to accept responsibility for anything, but it can be really useful to reduce the scope and expense of any ultimate dispute if you can narrow the actual issues that have to go to an ultimate dispute.
Thank you, Megan. Great advice there. So some gems in there. Watch out for unofficial, unguarded communications. I think I could write a book on those on a construction project over the years. Reservation of rights, not surprisingly, our legal brethren coming up with that one, and then lots of project administration tips from John. And again, Megan, you mentioned dispute review boards, and got to thinking, even regular sitting of dispute review boards to review risks on a project, especially a mega project, every 6 months or every 12 months, even if there isn't a dispute, it would probably be a very advisable process is to have a regular meeting of the dispute review board to review where the project is and to review where it's headed and where the risks are. So keep them informed, in other words. And the last one would be, of course, resources. When you get into a dispute of any size, an additional resource, and considering extra special teams and even hiring consultants and so on and so forth to get set up for it. So, fourth question, what are the challenges unique to mega project disputes? So we're in one now. So what are the biggest challenges you face, Alex?
Yeah, I mean, there are many in terms of managing the dispute. Evidence is usually a key consideration, so I'll focus my answer on that. And this is bearing in mind the scale and the complexity of these types of projects. So to make or defend a claim, obviously a mega project dispute, as would any dispute, requires substantial documentary, factual and technical evidence from a team of experts, but it's sort of multiplied up for the size of these projects. And so coordinating all of that can be a challenge. I discussed earlier some of the issues around collecting and ordering documentary evidence. And I can't emphasize how much your lawyers will appreciate all of that when it comes to preparing or defending a case. So in arbitration, which is where mega project disputes probably end up, factual evidence will commonly form part of the procedural order. So if you have a strong fact witness, that can bring many benefits to a case, not least that if they're credible, honest, genuine, they'll come across very well in front of the tribunal and they'll give valuable evidence. And that can be especially compelling if it's to explain the motives of a party when making or taking particular decisions. I think a key problem with fact witness evidence in mega project disputes is that the events subject to the claim are likely to have occurred many years before. So those involved have probably long since moved on to other roles and other projects. And assuming they can be contacted and they're prepared to give evidence in the arbitration, which is two fairly big assumptions, you're then reliant on their detailed recollection of very specific events that happened a long time ago. And there are known issues with this. So in 2020, the ICC Commission published a study called The Accuracy of Fact Witness Memory in International Arbitration. That study revealed, or perhaps reiterated, that memory is fragile and it can become easily distorted. I know that because I probably can't remember what I did last week usually. But an honest witness can be less reliable if the memory of events becomes distorted. And so the more time that's passed since the event happened, the more that's a potential problem. So witnesses with good memories, but that also keep detailed contemporaneous notes, are particularly valuable people. And also in mega project disputes, you will need technical expert evidence on a number of things, usually schedule delay analysis, quantum, and probably at least one technical discipline, but probably more. So identifying the right experts and coordinating them to work together can be a huge challenge. And in construction cases like the ones we're talking about, the requirement for expert evidence can be so niche that there may be only one or two suitable experts in the world. So sometimes the challenge is to engage that person before your opponent does.
Thank you, Alex. Over to John. What are the challenges unique to mega project disputes?
Actually, mega project disputes come with unique challenges because of the scale, complexity, high stakes involved. And from a technical standpoint, it's some of the key challenges I have experienced is complex stakeholder management, because mega projects often involve multiple stakeholders, including governmental bodies, private companies, local communities. Balancing their diverse interests and expectation can be difficult and challenging. High financial stakes as well, because the enormous budgets of mega projects means that any dispute can have significant financial implications, potentially leading to substantial losses or cost overruns. The extended timelines, the long duration of mega project increase the likelihood of changes in scope, personnel, and external conditions, all of which can lead to dispute. Regularity and environmental compliances. Mega project must navigate complex regularity landscapes and environmental requirements, which can be a source of contentions if not managed properly. Technological and engineering challenges. This innovative and often unprecedented nature of mega project can lead to technical difficulties and disagreement over solutions. Cultural differences is one of the reasons. When projects involve international teams, cultural differences can lead to misunderstandings and conflicts. Risk allocation, properly allocating and managing risk is crucial but challenging, as unforeseen issues can arise, leading to disputes over responsibilities and liabilities. So I would say actually addressing these challenges require careful planning, clear communication, and dispute resolution mechanisms clearly identified within the project execution plan earlier on.
Thank you, John. Some common themes there. Megan, challenges unique to mega projects. What are you thinking?
Yeah, well, I agree with the points that Alex and John have made. So maybe I'll talk about this from a slightly different perspective. And that's some of the challenges specifically in taking mega projects disputes through case preparation and submission through an evidentiary hearing. And, I think we've touched upon this before or earlier in this talk, but because the project record in these projects will be vast, sometimes getting down to a reasonable and actually digestible set of core documents for each aspect of the case can be really hard. And, again, this sort of comes back to the project execution, good project controls dictating the form in which key communications are made and discussions memorialized is going to be very helpful later on in putting in the dispute, together with, as Alex alluded to, thoughtful organization and how the documents are stored on the front end during project execution can really help. I also, picking up on one of the things Alex said, management of experts in a mega project dispute is really going to be of the utmost importance. And this goes not only to what they're instructed to give evidence on, but also in assuring that they have the information that they need in order to properly and confidently reach their opinions and discharge their duty to the tribunal. And so, while I think there's a tension between avoiding giving too wide a scope of instruction or burying an expert with documents and that objective, I don't think it helps anybody, especially not the tribunal, to try to keep material information from coming out in the dispute by restricting an expert's instruction or, the core information that they receive. And I think in that, it's also important that, especially in a dispute involving a mega project, that the experts understand not just what they've been brought in to testify about, but what other experts have actually been appointed and the scope of their instruction and where relevant the testimony that's been given by those other experts, if that is available to you in the proceeding. And that's so that they make sure to stay in their respective expert lane. And they don't fall into the traps designed to get them to sort of stray into other people's lanes and undermine what other experts have said. And I think just picking up on some of Alex's comments about the passage of time and what fact witnesses will and won't remember by the time they're called upon to give evidence in a dispute on a mega project, especially. I think it's important for all of us to acknowledge that the amount of information that a human being can refresh themselves on and retain going into their cross-examination is going to have their limits. And, especially where with many of the fact witnesses in these types of disputes, they're likely already employed full-time on another project. And so they're trying to juggle lots of things. And again, the information that they're being charged with recalling and telling the tribunal about is often vast. Sometimes it's going to be unavoidable that one witness has to carry a lot of that factual burden, including because of the unavailability, as Alex said, of others who are on the project but have moved on and aren't able to be there to help. But I think where possible, it can really help to kind of divide up the presentation of facts among several witnesses, with each being able to speak to really what are best within his or her ambit from their time on the job. And I guess just to close that thought out, Chris, it's just essential in taking a dispute through the process of putting it into the tribunal and getting to an outcome, that the left hand fully knows what the right hand is doing and that there's good collaboration between and among the teams as necessary. And I think, as Alex can attest from our time working together, I'm a big proponent of co-locating relevant personnel as much as possible, even if it has to be in a virtual setting, when preparing and trying these kinds of cases, so that you make sure that you've assured efficiencies, that you avoid confusion, and that you deliver as cogent and compelling a case as possible.
Thank you, Megan. That's super advice in there. And I was just thinking, surely lawyers don't set traps for witnesses, do they? You know, a lot in there again. The passage of time on mega projects and the memories of fact witnesses is an interesting one, and important to collaborate again and get the resources sorted, and co-located teams is interesting. I think the PR challenges come to mind. Now you're in a dispute, of course, and got to be high profile. How do you manage the release of information, especially sensitive information that might arise on a construction project of high profile in nature? So good stuff there. The fifth question then, and our final question, before we throw it open: what enforcement challenges might a party face in a mega project, given these projects are probably international and have lots of international parties involved and so on and so forth? So what about the enforcement challenges once the award's been made then? Alex?
Thanks, Chris. Yeah, and this is a huge topic in its own right, but I'll touch on two examples. And to set the context, assuming a party is successful and receives an arbitral award, that doesn't automatically mean it will receive the award from the other party, of course. So the award may need to be enforced. And most, but not all, countries in the world are signatories to the New York Convention, which requires courts in contracting states to give effect to agreements to arbitrate and to recognize and enforce arbitral awards made in other contracting states. And the arbitration laws in many countries are based on the UNCITRAL model law on international commercial arbitration. And that works with the New York Convention, so that the provisions for enforcing awards or for asking courts not to enforce or to set aside awards are the same under both the model law and the New York Convention. So two practical problems with enforcement in that context. The first is the location of assets. This has to be carefully considered when the arbitration agreement is negotiated, and before and then again during the arbitration, because if the award debtor's assets are not located in a New York Convention state, then enforcement can be more difficult, and it will require local legal advice in the relevant jurisdiction. And of course, it may be that practically the award just can't be enforced. And the second is insolvency. So attempting to enforce an award against an insolvent party has obvious problems. Any claimant will simply rank alongside other unsecured creditors, behind secured creditors, and preferential payments, such as winding up expenses. And so practically the award can be ineffective, because realistically the claimant is likely to receive nothing, or at best a fraction of the award value. And we've seen this in the UK recently. There have been several high-profile contractors that have become insolvent, and the number of unsecured creditors means that it's just unlikely there will ever be any sort of financial return. So if there are concerns over the enforceability of the award, I think parties always need to consider what other forms of project security may be available. So, for example, consider the position on any on-demand bonds.
Thank you, Alex. John, have you come across enforcement challenges that might face parties on mega project disputes?
Yeah, during my practical experience, I have seen several factors actually which are particularly challenging. One of them was jurisdictional issues, because mega projects often involve multiple jurisdictions, especially when international stakeholders are involved. This can actually complicate the enforcement of legal decisions and require navigating different legal systems. The complex contractual arrangement, because of the sophisticated and multi-layered contracts nature typical of a mega project, can make it difficult to determine which provision apply and how they should be enforced. Financial constraints, the high costs, I would say, associated with mega project means that parties may face financial difficulties in pursuing or enforcing legal action, especially if the project have already strained their resources. The political and regulatory challenges, government involvement in mega project can introduce political and regulatory hurdles that affect the enforcement of a dispute resolution. Changes in political leadership or regulatory frameworks can further complicate matters. Typical and operational complexities due to the technical nature of mega project actually make it challenging to enforce resolution that require specific technical expertise or operational adjustments. And last but not least, the stakeholder resistance, because of the diverse and numerous stakeholders of a mega project, they may resist enforcement actions, especially if there is a perceived that the outcome is unfavorable, or if their interests are not adequately addressed within the award, for example. So this is an example of a couple of the challenges I have seen, which require, again, robust understanding of the legal and regulatory environments involved.
Thank you, John. Megan, have you come across enforcement challenges?
Well, I would definitely say that I agree that financial constraints can be a particular concern in terms of enforcement of relief on mega projects, especially where the contractors might be JVs or special purpose vehicles that don't have other assets or projects in the country. And, the ultimate recoverability of any monetary award against a counterparty is something that I think should be considered from day one of thinking about even bringing a dispute. And of course, that's, as Alex said, that's why the existence and nature of project and performance securities are so important. And maybe that'll be your 2025 webinar topics. But for the purposes of disputes on mega projects, it's absolutely something that I look at from the very start of a dispute. I would say that another consideration in terms of enforcement is, again, what type of relief you're looking for. And if it's injunctive relief or specific performance, that can present other challenges, and especially getting enforceable interim relief can be quite a process. And if a party is unlikely to comply, for example, with an order of the arbitration tribunal, that might even involve a partial final award that's going to need to be brought to a local court for enforcement. So, I think that's a consideration, obviously, in any arbitration, but given that many participants in a mega project, as John alluded to, are going to be in many different jurisdictions, most of these projects are delivered by, international contractors and some combinations of them, who aren't necessarily going to be based in the country of the project by the time you get to a dispute. The types of relief being sought and the length of time that it might take to even enforce the relief that you've obtained are definitely considerations.
Thank you, Megan. I particularly like your day one comment there. There's no point in going into huge dispute processes if you're not going to be able to collect. Of course, very good advice. Foreign parties, jurisdictional challenges, and understanding of the anti-trial model law and the New York Convention, where most countries are signatories. That's very important too, right up front. Also, Megan, you mentioned interim and injunctive relief. You can see that if you had a dispute review board and it was progressive, that you very quickly flush out, whether something was enforceable or not, maybe in the early stages of a mega project, if there were some awards from the dispute advisory board or dispute review board. So some great information there. So we're going to move on now. We've got one or two questions coming in from our attendees. Here's one. What are the main contractual clauses and topics that, if not correctly evaluated and negotiated, may severely impact the execution of the project and lead to disputes? So specific clauses that cause problems. There's a good one for Alex and Megan. Can you think of any, guys, to start with?
Well, usually it's not having the clauses that causes the problem. So generally, I think, as we've spoken about before, construction contracts try to account for the unforeseeable in various different ways. So, if the owner instructs a change, there's a clause that deals with compensation to the contractor. If some unforeseen ground conditions are discovered, same thing. So usually there's a list of these entitlements that are designed to come into play when the unforeseen inevitably happens. The problem that I can think of in recent years is where those provisions haven't been there. And the largest and the most obvious recent example is the COVID-19 pandemic. So we advised a load of clients on contracts where there was no provision for there being a pandemic in the world. And so I think force majeure clauses were stretched to breaking point sometimes. Very few contracts said anything about pandemics specifically. Those that did, well, that was quite lucky. So it was a case of trying to find arguments to get compensation for that type of event that was pretty difficult, I think. And then the other most recent example is cost escalation. So there was a theme for many years when I was a junior lawyer that you never included cost escalation clauses in contracts because no employer would ever accept them anyway. Whereas now you have the opposite situation where contractors won't accept a contract without cost escalation clauses for specific parts of the work. So I think the world we live in has changed over the last few years. And so I think contracts are generally well set up. As long as it's a good contract, it should account for what's happening. And the bigger problem for me is when something happens that isn't accounted for at all.
Yeah, it's an interesting response there, Alex. And I hate to admit it, but I can remember the 70s where we had some index-linked contracts, 70s and 80s in the UK. The NIDO formula would be used to adjust because we were in times then of rampant inflation, as we have been lately. Megan, do you have any thoughts on specific clauses that prove problematic?
Not really specific clauses, but just picking up on what Alex just said, look, the three main things that are going to be in dispute are cost, schedule, and quality. And I think that where a contract doesn't give a good mechanism for addressing those three issues, especially cost and schedule, that's where you're going to get disputes. And so it's certainly a place where looking at contract formation and making sure that for the nature of the project, those contract provisions are robust enough to handle what's going to happen, especially, for example, if the design is evolving. And the contract is let before the design is fully complete. How is the contract set up to deal with that? But yeah, I agree with what Alex said, that sometimes it's when something got left out that it causes the most problem, as opposed to a specific provision itself.
Yeah, of course, COVID was a tremendous example of that. And I think, there's also some super examples of where the parties to contract just literally rolled up their sleeves and, right, we got to solve this. It's not in the contract, and how are we going to get to it? And there's some great examples here of projects that got finished really well by that collaborative mentality and mindset that we mentioned earlier. John, do you have anything to add on that one?
No, nothing to add much, but again, it's the mindset, as you were saying, Chris. It's basically changing the mindset a lot, especially during COVID and during the economical challenging periods recently, especially generally in the Middle East and especially in Egypt. Actually, having the employers and contracting changing their mindset to understand that the whole aim is to, as a team, is to deliver a project to the right level of quality within the correct budget and limits and within the reasonable time frames. Actually changing this and setting this mindset, working as a team rather than conflicting parties, as Alex was saying, this helps a lot in trying to mitigate actually disputes and try to find early settlements through negotiation or amicable settlement, neutral resolutions. Having an independent expert to get his opinion and try to solve things earlier and kill conflicts before it's escalate is became an important theme I have seen recently, especially in the Middle East.
Yeah, of course, we had a whole webinar on how to tackle problems brought about by COVID as well. So I've got one more question here before in relation to mega projects, what are your opinions on brought about by their very public profile, especially given the public relations and media challenges? And how do you go about addressing these challenges and managing information? And what comes to mind is, do we have hiring consultants and stuff like that, people who know about how to deal with it and how to deal with clients and what are their demands on managing information? Alex, you want to take a stab at that one?
Yeah, I don't deal much with PR issues for mega projects, but I think, thinking about the mega projects that, going on at the moment, I'm sure they have huge PR departments in their own right. And I suppose the messaging has to be quite careful in as much as it's trying to promote the project, establish the aims of the project, but to an extent be realistic about delivery. I think the worst thing is, as we've seen here in the UK over the last decade, I guess, is to say that, the high-speed rail project will cost X amount of £1 million And then it seems almost every year it's costing a lot more than that, to the point where it gets scaled back and it's still costing more than the full scheme would have costed to begin with. So, that kind of sliding scale of messaging, I think, is perhaps best avoided. But as I say, I'm not a PR person.
Yeah, Megan, what are your thoughts on PR and management of information?
Yeah, I think won't surprise you that I pretty much echo what Alex has to say. By the time these get to disputes, they're more often than not in a confidential arbitration. And so there's not going to be specific, or there shouldn't be specific information about a lot of these disputes being made public. But it goes back to something I was saying earlier about sort of these sort of poor or overly optimistic, or the optimism bias that can creep into some of the PR that surrounded the project from day one. And that can ultimately be one of the drivers of the dispute, is sort of, as Alex said, that maybe overly optimistic PR that then created expectations, and then created an unreasonable cost estimate or an unreasonable schedule for completion of the
Yes, John, anything to add?
Yeah, ask your legal advice about the PR thing. So, what problems you can do? Actually, from a technical standpoint, I generally try to avoid the impact about this and try to work, I would say, independently in a bit of a silo thing, just to make sure that I have the proper judgment about it, rather than being affected by I would say, public views and others. So just try to focus on the dispute you're trying to resolve, and try to communicate with the parties. Just let's focus on resolving this dispute, rather than focusing on side matters, is an important thing.
Very good, very good. Well, we're going to wrap up now. I wanted to thank our experts there for their contributions. A highly interesting topic. I also wanted to thank the CIOB and the RICS and the ACCE for their support of this webinar. If anything we discussed today raises questions or concerns on your project, please email us. Again, our email addresses are on the slide, or they were, and they'll be on the recording. Or connect with us on LinkedIn and ask us the questions directly. We truly hope this session has been valuable to you as attendees, and thank you all for being with us today. And goodbye from our teams in Atlanta, London, Dubai, Cairo, Melbourne, all over the place. So we've come together to give you this webinar. Thank you very much for attending. And if you want to go over it again, it'll be on YouTube. Thank you and goodbye.
Thank you, everyone. Bye.